Good evening, everyone. Welcome to the October 2015 Zoning Board of Appeals Town of Carmel meeting. The board members' names are all in front of you. We have our town council, Greg Fulchetti, and code enforcement officer, Mike Carnazza. Would everyone join me for the Pledge of Allegiance? Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. How we operate is we'll hear the cases all in succession of the agenda, at which time you come up, present, I'll swear you in, present your case, and then we'll ask for input from the public. Once we close the hearing, there's no longer any input from the public at that point. Just one note I want to share with everyone. This Sunday at 11 o'clock in the Mapac Chamber Park, they'll be having a little ceremony for Mark Frazier, who was my predecessor on the board and our former chairman who's passed away this past spring. And they're having a little commemoration in honor of Mark. They're planting a tree. I believe his family and friends will all be there, and they're inviting the public and board members and town members who would like to join and celebrate the life of Mark, who we share the loss with the family, and prayers for his family as well. So just wanted to make that point, public notice. All right, our first application tonight, which was a holdover, is number one is Gino Barbero.
I'm recusing myself.
Okay. Bill representing.
William Schilling representing the applicant. I have,
Bill, can you just affix the microphone to your...
all I have to do is,
Barbero's going to speak, and I need to swear you in.
he may.
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, Bill, let us know what's going on here.
Good evening. My name is William Schilling, and I represent the applicant in this matter. The applicant is Gino Barbero, who owns a restaurant in Mapac, long-standing roots in Mapac. Not an absentee landlord. He's right on the site, often keeping the premises neat and orderly. The property we're going to talk about is 303 Bucks Hollow Road, and the property consists of a 2.5-story brick three-family, and it's a three-family by virtue of a ZBA decision in 2000, and that consists of one two-bedroom apartment and two one-bedroom apartments. The survey will show, if you could open that, Gino, that the parking is served on the three-family. Can you open it? By parking all around the structure. There's a big parking lot here, and people park all around the building. What we're going to talk about tonight is the 1.5-story brick garage building with an apartment above. That is the topic for tonight. The property is located on Bucks Hollow, which you all know is a very, very diversified neighborhood. There's a series of mixed uses throughout Bucks Hollow Road. There are many multi-families. There are single families, there's retail, there's commercial across the street and offices. Right across the street is Route 6. Route 6 is separated with the subject property by the bike path, which came in the 2000s. Notwithstanding all that, the zoning is a residential 3-acre. The garage is set back from the three-family. There is no use to the tenants for the garage. And as I said, there is ample parking for all the tenants that are currently in the three-family. What we're seeking from this board tonight is your modification of a decision in order from 2000, which required the garage apartment to be eliminated. And I've provided you case law that says you do this through your interpretive powers, that this board has the right to interpret condition for a decision in order to be either obsolete, illegal, or not justified in the findings of the decision in order. In the alternative, we're looking to expand a non-conforming use to permit another two-bedroom apartment to continue in this single-family zone. In support of what we're seeking tonight, we've submitted a memorandum of law and Gino's affidavit in support of the relief we seek this evening. The factual background starts in 2000 when Gino's predecessor in title, whose name was Callisto Burton, petitioned the zoning board to seek approval for the three-family, or to seek legalization of the three-family and the garage apartment. In that application, which I've attached to you or for you, Callisto Burton swears that the garage was furnished and was converted to living space in 1968, which is 47 years ago. The ZBA in 2000, by decision and order, granted the status of the three-family, but stated in its decision as a condition that the garage apartment should be removed or eliminated. I urge you to look at the decision in order and say to you, there's not one mention, not one rationalization, not one supporting sentence in support of that condition. It's completely barren of any justification, except at the end it says the single family or the garage unit must be eliminated. And I submit to you for that reason, by law, it's legally flawed. There's no rationalization, there's no mention of two reasons why the garage apartment should be eliminated. In 2002, my client purchased the property unaware of the restriction. And at that time in 2002, the current residents of the apartment moved into the accessory apartment, or to the garage apartment, so that for 13 years, the same tenant has been in that apartment raising their two children. When my client purchased in 2002, he was completely unaware of the fact that there had been that zoning board decision requiring an elimination of the garage apartment. I have a municipal search from the title company at the time in which the statement from the service says there were no violations of record. And I'll be happy to show that to you. Now, it does say that there was a legal three-family in the garage,
Thank you.
but it does conclude that there were no violations. I know from a standpoint of a building inspector that a building inspector doesn't always make an inspection. Oftentimes, the service gets their facts just on the paper that's in the file conducted in the building department. But my client will swear, and I ask that you put him under oath to swear, that he did not know of this restriction at the time he purchased the property in 2002. And in fact, shortly thereafter, within the next couple of years, my client spent $15,000 in making the apartment not only habitable, but decent for living. So that condition was unknown. Later on, in the 2000s, the bike path was placed immediately behind the property, making the property even further diversified and making it less and less contemporary single-family zone. I've provided you some financials. Currently, the debt on the property is as follows. The taxes are $1,400. The insurance is $250. This is all a month. The taxes are $1,400 a month. The insurance is $250 a month. The oil is $750 a month. The landscape $150, repairs $300, and the mortgage is $3,200. That means that Gino's carrying costs for a month are $6,000. The revenues generated from the three family are $906 for one apartment. Apartment number 2 is $1,000, and apartment number 3 is $1,550. So without the revenue raised in the apartment, he's at about a $3,000 shortage. Currently, he gets $1,450 for the garage apartment, making his loss per month about $1,120 a month. And that's why we're here, because not legalizing this apartment would be really a devastating blow to Gino, who will testify to the fact he was unaware of the restriction set forth by the zoning board. On the issue of the law, I've provided to you absolute authority that you have the ability and the responsibility to impose conditions. It's under 267B of the town law. But it's equally clear that you have the right and the responsibility to modify decisions in order under the same section of law, 267B. And I provided you case law that provides that conditions of a decision in order can be modified if there is no rationale for its decision, if the condition became obsolete, or if the condition at the time of imposition was deemed illegal. I've also provided you authority that says modifying a decision in order is done through your interpretive powers, that you have the power to interpret that the condition is obsolete or that the condition had no rational basis at the time it was made. And for authority, I provided you a case that's called Red House that's in your submission. So you do have the right to modify a decision in order. You have the right to remove a condition that you find to be obsolete or not founded in fact. And again, I'll stress to you that there's nothing there in the decision in order that speaks to why they thought the garage apartment should be eliminated. And for that reason, I submit to you it's invalid. There's not one reference in the decision in order as to why the removal of the garage they thought was mandated. I also submit to you that without question, the condition is obsolete. It's now 47 years in use. My client has owned it for 13 years without incident. And the neighborhood has further changed in that the bike path now is up against the property. And the property continues to be very, very diversified in its character. So we would request, through your interpretive powers, that the condition imposed by the board in 2000 be removed as it relates to the removal of the garage apartment. In the alternative, should you wish to continue in another manner, you could find, in my opinion, that the expansion of the non-conforming use is justified here. And those standards are use variance standards. And the first thing is that of reasonable return. I've provided you that even with fair market rentals and legitimate costs, even with the garage apartment, he's down to over $1,000 a month. And there's no way to gain a return. There's no other rents to collect, and the rents are at market value. I also want to stress to you that the law is clear that when the neighborhood won't be changed, that the burden of economic hardship is reduced. If the neighborhood in its present shape, what we're proposing, will not be changed, then the burden, the financial burden, is reduced, and that's well-founded in New York law. With regard to uniqueness, I submit to you that many of you know the applicant. He wouldn't have put $15,000 into this apartment if he knew that there was a chance that it would have to be capped. And for that, I believe that the application is unique. You have a family that's been there 13 years. With regard to the neighborhood, which the courts have called the most important criteria, we put together a tax map rendition of the neighborhood. The area in pink is multifamily and in orange is commercial. The green site is the subject property. So you can see by the colors, there's not a real single-family nature here. It's a very, very diversified neighborhood. The use has been in existence since 1968. I would also like you to take a look, if you can, of the photographs that Gino has taken for me of the apartment. The apartment, as I said, isn't just habitable. It's a very, very nice apartment. Proof of that is a family has stayed there for 13 years. This neighborhood wouldn't be changed by you granting the application. It would be bettered. It would be improved. And so I submit to you that the neighborhood will not be affected one bit by your application or your granting of our application to permit another residential unit on the property. This is not a self-created hardship. My client, perhaps the attorney missed, perhaps the title company missed, whatever the case may be, Gino Barbera bought here thinking that this was a legal unit and spent a lot of money in upkeep and in beautifying the subject property, so it's not a self-created hardship. So, in conclusion, I ask you to modify the decision in order because you find that there were no findings in the decision in order, or because you find the condition is obsolete. In either event, I believe you're well justified in your decision. Or if you choose to go on the issue of an expansion of a non-conforming use, all of the 4 criteria are met here. The neighborhood won't be changed. There's no reasonable return. It is unique, and it's not self-created. I'll entertain any questions, as will my client.
Bill, how many parking spaces are on the site?
Up on top, there's 4. You go down to the property in front of the garage. Both garages, there's probably another 3, and behind the garage, there's probably another 6 or 7 parking spots. So there's a total of at least 12 to 15, about 12 to 15 spots there.
Thank you.
All right, Mike, any questions?
One thing I didn't see in the materials, I read the resolution, there's not a lot in the resolution, but is there something, are there meeting minutes from this
Yeah.
meeting that, did you submit those?
I did not.
I mean, maybe there's something about the
There
rationale for the
was.
condition
There
in
was some reference to the garage apartment and thinking, one member said that they were concerned about another apartment, but it never found its way into the decision in order. And I think by law it had to in order to be binding and or to be effective resolution.
Not sure about that. Do you have copies of those minutes, or
I can provide them to you? Sure.
if, I'd like to see those, I think.
Okay.
Rose should have them too, if you need to get a copy. Have Rose get them to you guys.
In response,
No
if I might just respond to it, I'm hoping that that won't result in a holdover. And I'll submit to you that there was, I believe there was one board member that mentioned that. And I stated for the record, and you can use that in your deliberation. But my point was, it never found its way. For all I know, the board disregarded that concern because it didn't find its way into the decision.
You have the finding of fact here in your packet. I'll read, the parcel, finding of fact, the parcel consists of a parcel approximately 110 by 150 feet and is improved with a 3-family dwelling containing 1 2-bedroom apartment and 2 1-bedroom apartment, and detached garage, which was converted to a 2-bedroom apartment. The applicant is the trustee of this deceased, well, it goes on, but, I mean, it's actually cited in.
Oh, it's cited, but it's, in its conclusions, in the decision in order, it doesn't say why, it doesn't provide a rationale for why the garage apartment should be eliminated.
Bill, could it be that that board, and again, I can't speak for it because obviously that was a long time ago, but again, the role of this board is to reduce the substantiality of a variance. I mean, that would be an obvious answer to that, wouldn't it? That you would have 3 apartments as opposed to 4.
I think the role of the board is to administer justice.
I understand that, but I'm
think
just,
I don't know what the rationale of the zoning board was. If you're not comfortable with the decision not containing it, then I would ask you to pursue or to review other means that I'm asking you to, for example, the fact that it's obsolete after 47 years, and perhaps do your evaluation about expansion of predated or non-conforming uses with the 4 criteria of a use variance.
Okay.
I would be comfortable in that review.
Okay.
Mike, after this decision, was there an inspection done by the building inspector of the garage to confirm that it was no longer habitable?
Mike, I can answer that for you.
I believe the answer was yes, but I don't have the file with me, so I don't want to say exactly who did what. Okay, yeah, we did a pre-existing letter, and there was a CO that was issued March 13th, 2001.
On the
It
garage?
was for a 3-family dwelling and a garage.
As a garage?
It says 3-family dwelling and a detached garage. I'm
But it goes
reading what I
on,
wrote. This is what I wrote.
and then it concludes by saying there are
No
no,
violations of record.
there are no apparent violations of record. I don't, from what I read, I don't think Mike did an inspection, and if he had, he would have picked it out.
Of the garage, probably.
Yeah.
I mean, we definitely saw the 3-family.
All right, thank you. I have nothing further.
How did this get here?
Sorry, now?
How did it get here today?
How did it get
Yeah,
here?
why are you here? Were you,
I think Joe's fire inspection, right?
Yeah, it was
Joe
right,
went
yeah,
out for
yeah,
fire inspection
fire
and
inspection, yeah.
okay. I
determined
just
the
wanted to see how it
additional
got
unit.
here. I was just curious. Okay.
Just to clarify, when I purchased the property, there was somebody living in there, young lady, and my introduction to landlording, 2 months after I purchased, she got into an accident on Route 6, she passed away.
Oh, goodness.
So, yeah, so the apartment was the way it was, I just had to clean it out, and that's when I got this family in. So, like I said, I purchased it with I did the bank financing, bank did their inspection, they said nothing to me, so that person was living in there. And like I said, 2 months later, after I took it over, she passed away. It took me about 2 months, about 2 months to fix the property up, because like I said, this is my first experience, and I put this family in there. I knew them because he worked with one of my friends, and like I said, he's been there for 13 years, so.
Okay. At this point, I'll open it up to the public, and then we'll have to decide whether to interpret or in the alternate to go with use variance standards. So, anybody in the public have anything to say or questions on this application? Okay. I guess at this point, I'll look for a motion for, if there's a positive interpretation on, the applicant's looking for interpretation that the 2000 decision in order be modified to permit the garage dwelling unit to continue. So alternately, we would have to, he'd look for a use variance to permit the same to continue. So, that being said, do I have any motions on the interpretation?
Before saying the resolution's obsolete, or the condition is obsolete, I would like to see what happened before, so I can understand better the reasons behind imposing that condition.
So, in other words, you're looking for the minutes from,
Maybe the minutes, or maybe something else that's in there too, yes,
Could
I
I,
don't know. don't
could
know
I
if there's
ask a
stenographic
request of the
record.
board? May I?
Certainly.
If the interpretation is something you'd like to defer until you read the minutes, could I ask the board to judge this on expansion of non-conforming use standards? That would have nothing to do with your, in other words, could we treat it separately? If the board wants to hold off on the interpretation and make a decision on the expansion of the non-conforming use, if we're not successful in that regard, we'll come back next month on the interpretation issue,
Reserving on the interpretation.
reserving on the term.
He's asking if the board wishes to decide the variance portion of the application that he's made a submission as an alternative theory. And you can do that, and what he's suggesting is you can do that, and if you don't grant the relief that he's seeking, then you can come back next month after Mr. Schwartz and what other board members want to look at the minutes from the meeting where the initial variance was granted, and then you can actually be in a position to act on the interpretation, because they're independent determinations.
Okay.
It's up to you.
I'd have no
You want an
problem with
answer?
that, John.
Yeah, so, all right, we'll do that. So we'll table
Some
this.
sort of answer.
Just reserving his right to still
But he wants an answer
Or do you
tonight
looking,
of some sort.
Do we make
I'm
this
asking the
decision now?
board,
Based on the use variance
on
criteria.
the expansion of the non-conforming use.
So we're closing the public hearing on the
close the
use
public hearing.
variance part of it.
So at this
I'm not
point,
sure you
we'll
can't
the
close it
public
on
hearing.
both. I think it's,
Yeah, because at that point, we're just
I
going
think
to
it's just a matter, you can
Yeah, we can
reopen
reopen
or
it.
it's a matter what the board members want to look at before.
All right,
they
so I'll make a
get
motion to
the
close the public
interpretation
hearing.
part.
I'll second it.
All in favor?
Aye. And then we'll deliberate as a use variance.
So can we do that at the end of the meeting, or do we do this now?
It's your procedure, whatever, if you're going to do, hold everything to the end, then hold everything to the end. If
That's
you're going
what
to
we
vote
should
now,
do.
then vote now on all.
As we typically
Or
do,
vote.
so.
Yeah. And we could get Rose back in.
Okay.
Thank you very
All
much.
right, thank you, guys.
Thank you.
All right, number 2, Lupi Plaza,
I'm going to recuse.
Condo Association, and Wayne DeRosa. All right, guys, you all plan to speak? Raise your right hands.
That's fine.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
And state your names for the record.
Wayne DeRosa?
G. Trulia?
Steve Morrison.
All right, and just be sure to speak into the microphone. All right, you guys were here last month. I believe we held this over because we were not sure of certain terminology, and I guess we'll reopen the case. Why don't you guys tell us what you're looking to do here again, just for the public knowledge?
Just to recap, we're looking to get approval to erect a sign on the right-of-way of Lupi Court in Mahopac, right off of Route 6 for Lupi Plaza Condo Association and all the tenants on there. So we're looking for that approval.
Currently, we have no signage whatsoever, with exception of a truck.
All right, you guys did get a positive letter from the highway superintendent. It was suggested that if this goes forth, you'd have to get an actual permit from the highway department to get the sign in the right-of-way.
A permit?
Correct.
Okay, that's fine.
So, Mike, is there an actual form or for them to get a permit from the highway department?
License or?
There should be a permit they can get from Highway. If the board's inclined to grant any relief under the application, I would suggest that it's conditioned upon the issuance of a permit from Highway for any of the work or the improvements that are
So
being
is this
done in the
some-
right of
is
way.
there- He would have to reach out to
Driveway permits, there's highway permits, okay? I'm not sure where it would fall in the category.
just like as if you had to get a curb cut, you know, you'd have to apply
Fine,
to the-
absolutely.
Okay. So I'll go to the board members for any questions. I mean, continuing this from last month.
No questions at this point.
No questions, thank you.
No questions. I don't have any questions.
Questions?
Does any input from the public at this point? You are an attorney, correct? I didn't- You swear you.
I am, yes.
Okay, state your name for the record again, please.
Richard Blancato, I'm the attorney for the neighbor of the storage place. At the last meeting, I indicated my objection based upon the language of the ordinance, where it says no sign shall be permitted in a right-of-way, and that's an absolute prohibition put in the ordinance by the town board, and that this board didn't have the power to grant a variance. I'm withdrawing that objection. And the reason I'm withdrawing the objection is we listened to the applicant at the last meeting, and it is my understanding that there is no sign and that they actually need the signage. We don't want to prevent them from getting signage. I explored trying to put the sign on the opposite side of the right-of-way. And after discussions with the building inspector, I understand that coming from the town hall side, you couldn't see it because of the wetlands. And it has to be back certain length because of the state right-of-way. I looked at the sign that's proposed, and it's 6 feet high, although it's lower than our sign, because our sign's up on a hill. My first request is, can it be lowered to 5 feet? The second is a question. It looks like it's an illuminated sign, and my question is, where are they going to get the electricity for the sign if it's illuminated?
Okay, I'll give the applicants a chance to answer those questions, because we don't know the questions or the answers ourselves.
Okay. We would like to keep it as that, at that height, at that right height requirement. You think of snow coming in, plows coming through. I mean, look at the winters that we've had, things get stacked up. So we're thinking at that height right there, we should be good because we're gonna have possibly 11 tenants because that is all the
units.
possible tenants and units that we have at the plaza. All those placards being filled, there's gonna be obstruction somewhere along the line. So we would really appreciate keeping it at that height. I mean, technically, it could have
On
went
that
higher,
question,
but we don't
Wayne,
want
is
it.
this representative of, in scale, of what you're looking for?
Yes,
Because I would say it's clearly not in any impedance to your client's sign.
it is. And you can actually, I'm sorry to interrupt, even the number 5 of where it says their address, 5 Loopy Court, is not even blocked on there from a distance. So really, the only thing that, if you want to say it is obstructing, is their post, which it has no advertisement on.
So basically, this depiction or this picture is to
That
scale
is-
of what?
That's the scale, yes.
And as
Correct.
far as the electricity, we already have electric out there that would be on our meter from
Yes, that's on
the
our
original
meter.
sign that we
So
have.
you're gonna tap off your feet
Yes.
coming
Yeah,
into
we
it?
have a feed out there.
And it's on that curb side?
Yes.
Yes.
Limited,
Okay.
no higher than 6 feet or something.
You'd have to step that down. I'm sure it's higher voltage, so you'd have to have a transformer of some sort?
All right, that's my electrician. He takes care of it all.
It worked before.
There is a meter right across the street that we use for our plaza.
It's a fenced-in area.
Okay.
Going on the right-hand side. I would just ask, as a matter of fact, I have to see the electrician this week about other things. I was gonna ask him what it would take to feed
Yeah, I'll
off that
share 'em.
meter and that circuit to run it over there, even if we form a certain breaker, a separate breaker, and so on and so forth. But it
Alright.
would ever be,
So
everything
you
would
have a
be
means
sold.
of getting electric to it without
Absolutely.
impeding or
No,
interrupting
none,
their
none
property?
whatsoever.
There's all the piping underneath the roadway, I guess, when they built it.
Okay, well, you guys would do that across Route 6?
No.
There has been, yes, there has been piping. That's where Mr. Lupinacci, when he first built it, the electricity's coming from across the street. They piped it under. It is there.
Okay,
On
so
Loopy, this is on
so
Loopy
you'd
Court.
have to tap it off of your side of the street?
My side of the
Yeah.
street, and there's piping underneath, and that which would go to there.
Okay. All right.
Our sign was originally hooked into that electric.
Oh, really? Okay. Do you have any other concerns or questions for the applicant? Okay. Does anybody else in the public wish to speak on this application? All right, I'll look for a motion to close the public hearing.
Motion to close?
Second?
Second.
All in favor?
Aye.
Thank you, guys.
Thank you.
All right, new applications tonight. Well, number 3, Carmel Fire Department Sprint Corporation has asked for an adjournment. I'll look for a motion. Good to see you.
Motion to hold over?
Do I have a second?
Second.
All in favor?
Aye.
Okay. I'm sorry, that was a holdover application. New applications tonight. Number 4 is New York SMSA Limited Partnership doing business as Verizon Wireless.
Good evening.
Good evening.
My name is Jordan Fry. I'm from the law firm of Snyder and Snyder, 94 White Plains Road, Tarrytown, New York. Also with me tonight is Ekta Shaw of KMB Design. She's the project engineer.
If she's going to speak in, I have to swear her in.
Sure. When she's ready, if you don't mind. We're here tonight on behalf of New York SMSA Limited Partnership doing business as Verizon Wireless. They have an application currently with the planning board for site plan approval for a public utility wireless communications facility. And the planning board had referred Verizon Wireless to this board because the existing building was built before the zoning code was in existence, and there's many nonconformities. Although Verizon Wireless's proposal doesn't increase any of those nonconformities, it's my understanding it's the town's practice to clean up the application, and in connection with the zoning code or the zoning inspector's direction, we're here to get the variances for the actual building itself, not Verizon Wireless's proposed installation, except for one. One variance is for parking. So Ekta, if you want to be, you might as well swear in Ekta, and then we can move forward.
Raise your right hand. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Just state your name again, I'm sorry, for the record.
Ekta Shah, last name Shah, S-H-A-H.
Okay, thank you.
So just to give the board just a quick overview, Verizon Wireless simply is proposing to install small panel antennas on the outside of the building. They'll be flush mounted to match. And again, we are here tonight to get variances to, as the town likes to say, clean up the site. So the variances are area, width, depth, front yard, side yard, rear yard, floor area, height, building coverage. That's all with respect to the building. And then for public utilities, 2 parking spots are required, and there's none available at the site. With respect to the parking, the site is unmanned. It gets visited once a month approximately, so there really shouldn't be any issue with respect to parking for Verizon's facility.
That's with a van, a service van, or?
It's a typical SUV. It's not, could be a service van, but usually it's an SUV. Some of the other sites, the engineers need to drive through roads.
And they would just park on the street as
Exactly.
is the nature in the middle of town there anyway.
Correct. And then again, with respect to the installation, there's going to be no increase to the nonconformities. We're just following the town's practice to seek the variances on behalf of the building. To kind of just quickly run through the 5 factors for the zoning board, we've detailed it more in the memo we've submitted, but just for the record, we respectfully submit there's going to be no undesirable change to the neighborhood because, again, Verizon Wireless is not increasing any of the nonconformities. The antennas are going to be painted to match. There shouldn't be any change to the neighborhood. There's no other feasible method. The building's been in existence for many years, and Verizon is just simply using it to place small antennas. It's not substantial, again, because there's no change to the actual building itself. There shouldn't be any adverse effect on the physical conditions of the neighborhood. Once again, Verizon Wireless is not changing the actual footprint of the building. This condition's not self-created. Again, the building was there before the zoning code was in existence. And regarding the parking, again, it's only going to be, it's an unmanned site. There should be no impact to the neighborhood.
We actually used to have a different zoning code, CB or something like that. It was something different where there was a 0 setback on the side, but when we redid the zoning code, we redid it with setbacks for no matter which zone you were in, so that's why they're getting captured this.
Okay. So
Little
these
different.
antennas are basically up on the roof? And
They're actually on the side of the building. They were up on the roof. The planning board requested it to be, the antennas to be flush mounted on the side of the building and painted to match to be camouflaged. So we made that change.
Okay, what size are the antennas and what's their physical makeup?
Nothing to do with it.
Sure.
There's nothing to do
Ekta,
with
correct me if I'm wrong, but I believe the antennas are approximately 4 feet tall. And again, they'll be painted to match the building. And we also submitted visual simulations for this board, if you'd like to take a look.
No, that's fine. All right, I'll poll the board. Sylvia, any questions?
No questions.
Rose?
Do I understand you correctly that there will be no extra height beyond the roof itself?
Correct.
Correct, because I believe as it was originally proposed, it wasn't going to extend beyond any bulkhead. But now the antennas, I know for sure, are flush mounted on the side of the building, so of course they're not going to be above the rooftop.
So there's nothing at all above the roof?
Is there-
Okay.
There may be some ancillary equipment, is there, or is?
There's some ancillary equipment, but they'll be on the parapet on the inside of the,
Correct.
roof.
So we won't
be able to
see it?
see
It's still hidden.
They'll still
It's
be
all
hidden.
gonna be hidden.
Okay. Other thing, I guess for Mike, parking for the apartments as they are right now, do they conform to code?
Nothing in town does.
That's downtown.
So not only, they're looking here for 2 parking spots for public utility.
That's the addition that's required now. All public utilities require at least
Two,
two,
I
I think it
That's
says,
our
right?
town
Yeah,
code
it
that
says
says
at
that.
least 2 in the code, so that's the only reason they couldn't be required to get more parking.
But if this is a non-conforming and we're trying to bring it into conformity, shouldn't we have listed X number of parking spots for the apartments that exist? In other words, instead of 2, shouldn't we have listed, 6 apartments or 6 more? Isn't it misadvertised in a sense?
I don't think so. I mean, it's the addition of what's required. There was 0 before.
What was required?
How many units are there
You
total in the
didn't
building?
meet-
Do you know?
I'm sorry?
How many units are in the building?
How many units?
17 units.
And the commercial has space as well.
That's what they're seeking variance from.
They're only asking for 2, though. Shouldn't they?
Just for the utility.
Technically,
Well, for the utility portion of it.
but
correct.
technically, shouldn't, if we're bringing everything into conformity, shouldn't it show, I don't know, the 17 plus the 2?
Should that be part of the cleanup?
That's my
We're
question.
happy, if the board, we're happy to, if we can amend the application by way of this meeting, and we're happy to request the variance for all necessary parking required under the code as determined by the building inspector. If you can make that a condition to approval, that would be perfectly fine.
Okay. We're just talking about the utility.
Yes, it's at planning right now.
So, I mean,
I'm sorry?
The bulk parking requirements would be on the final site plan, no matter what.
So it may come back here anyway. So it may come back here anyway if they catch it and they decide to push it up or no.
But, I mean, they can show the parking on the plan.
Oh, then we're done.
Before they get site plan approval.
Okay.
So if you're considering, you can condition it upon, bulk parking requirements as to be determined by the Town of Carmel Planning Board.
Kick it back to them. Okay.
I mean, the bulk requirements here are the area and the setback and the depth and the height. Those are the things you're really stuck with here on the application, a good number of them. But you can certainly do that because they're, as opposed to those things which already are in existence with the structure, the planning board is not, they're gonna kick it right here for those items. But with respect to the parking, they're gonna go back there with a site plan and the planning board can require the parking to be shown on the final approved plan.
Yeah, just to clarify, I'm happy to speak with Michael, and we can calculate how many parking spots the variance is for, and if you could make it a condition on your approval that the variance is as determined by the code enforcement officer, and as approved on the site plan, we'd be happy to do that, just to bring it into conformance. Again, there's no change to the neighborhood with respect to this application.
Right, it's just that if we're cleaning up, I just thought we should be
Yes,
cleaning up
that
everything.
would be great. It would just be very helpful if we can make it a condition of any approval so that Verizon Wireless can hopefully get their site plan approval and start providing service to the area rather than coming back.
Okay. Bill, anything?
No questions.
No questions.
All right, anybody in the public have any input on this application or questions?
I have no further questions either.
Oh, I'm sorry.
Phil and I were just talking about that. He doesn't exist anymore.
I lost some weight.
All right, anybody in the public? Nobody has any, okay. I'll look for a motion to close the public
So
hearing.
moved.
Second?
All in favor?
Aye.
Okay,
Thank you.
thank you.
You make your decision at the end, correct?
Yes.
Correct.
Okay, thank you very much.
All right, number 5, Joseph and Karen Bosley? Baisley, I'm sorry.
My name is Tom Casey. The Baisleys are out at a funeral tonight. I'm representing them.
Sorry about that. Can you raise your right hand?
I do, yes,
Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Let us know what you're looking to do here.
We're seeking a variance to, we want to, the Baisleys own a piece of property.
We have.
Yep.
The variance is to build a deck on the property. Existing code requires a 25-foot front. We're looking for, it says here we're looking for a 20-foot variance, and it would be a 5-foot on the lakeside? That's on the roadside?
Front would be the road.
Roadside.
Okay. 10 on the side, each side, we're looking for a variance of 9/6 on each side, so it'll be 6 inches of property on each side of the deck. And on the rear is 0. So we're seeking a 10-foot variance on the rear.
This is not a dock. It
This
is
is,
a deck.
this is a deck, we're not gonna go over the water, up past the
So you're
property
going
line
right
into
up to
the
the
water.
shoreline enough
Maintain
for...
that finger that's there, that's already,
The finger that's there, that's existing, we're gonna maintain that there.
okay.
And the deck is this, instead of bringing the steps down on top of that, the deck, the stairs will be built into the deck, so we'll walk down to the property line and step
Just
on that
level off
finger,
at
yeah.
that, okay. I mean, it's not too out of character with that side of the lake. It seems like every property along there is full deck to deck. Some of them have full greenery, but, you know, there's some portions of decks on every property. I was out there last night, again, looking at it. So I don't think it's out of character with the neighborhood. You know, and it's a tight lot. Looks like you have a fence on each side for
There's
privacy.
existing fences on each side.
Okay. I don't think, well, I mean, it's kind of substantial for the side setbacks, but again, it's a small lot altogether, not really much usable land, so. Start down this end. Mark, anything?
I have no questions.
No questions from me.
No questions.
Bill?
No questions.
Tom, quick question. So
Yes.
it's gonna be 20 feet of grass, and then the deck starts?
Yes.
Mike, just a quick question on this one. Do we have to worry about lot coverage on this, or no, because it's... Only because I saw the size of the deck, and I went back and
That's
went,
fine. Let me just take a peek and see what it says exactly.
There's obviously no other property that can be bought. I mean, each side
No,
looks like it's well,
That was the only piece of property left on that side of the road there
Right.
that they purchased.
gold mine.
Yeah, well, they own the house right across the street.
Oh, that helps.
Somebody else owned that property. They've been renting that property for their boat for the past 8 years.
Really?
Yeah.
Lucked out.
Buildings or structures.
What kind of decking material? Just curious.
It's all gonna be man-made, you know, Trex and
Okay. It'll be open up to, it's not gonna be tight. You're
it'll
gonna
be
have seams in
open.
between.
There will be a, I have it with I'm going to the ECB meeting next month to get that all straightened out with the impervious features of it all.
Yes, it does need to be
There needs a...
the coverage.
Okay. Because I saw that
It
one.
is a structure, because it is more than 12 inches from the ground.
Okay.
It will be on the water side, yes.
No, but
You have to hold this
the
and
application's
re-advertise.
incomplete. Because you need,
Component of variance, it has been advertised in that model.
right,
It's been advertised.
sorry.
Impervious surface.
No, the deck.
I'm sorry, I'm not
The
getting.
deck's got lot coverage. It's covered.
You're only
Your
allowed
lot
to cover
coverage
35%. Oh, sir.
Is over a certain percentage. I mean, it's almost 80% of the lot. If you
Right.
do a quick deduction, which you shouldn't be over. What is it, 35?
35.
But it didn't get picked up or advertised in your application. So by law, we have to hold it over because it's not, it wasn't advertised properly.
Okay,
So,
What zone is
we're gonna have to hold it over.
all right.
Are you residential?
R is 15?
All right?
The deck is not going, is gonna, you're saying the deck's gonna be 80% of the lot size?
No, more than 15%.
More than 15? Yeah, it is. It's gonna be about 53% of the
Yeah.
lot
Yeah,
size.
so you just need the variance for that, too.
Okay.
That's the only- That's the thing that was missing.
All right, so there's an additional variance that has to be
Yeah, right.
requested.
Yeah.
So you re-advertise and put that on as part of the application?
Mike, you'll let
Come
Rose
see
know.
me, we'll get it on there.
Great,
All right?
we'll do that.
So at this point, I'm gonna look for a motion to hold this application.
Since I found, I'll make the motion hold over.
Second?
Okay, and we'll reopen it next month. I didn't ask if any public input, but looks like,
Yeah, we're open. We're holding it over.
so, all
Done?
right, we're sorry about that. but
Thank you. No, appreciate it. Thank you.
Do it now instead of getting picked up down the road, you know?
Yeah, appreciate it.
Right,
Thank you.
All right, thanks for your time. Have a good night.
Oh, yeah. Yeah, take the vote.
Yeah, for the holdover, all in favor?
Aye.
All right, thank you. Number 6 is Charles Bayer.
Hello, everybody.
Hello. You are?
Walter Horn, I came down to represent them.
Okay, will you raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, let us know what you're looking to do.
We submitted a variance and some plans to construct a deck on their property. I submitted everything that I needed to.
Okay.
2 houses on 1 lot.
Mike, that's what we were looking for clarification earlier. There's no need for any setbacks here, because nothing was advertised on our packet, and we don't know if it was advertised as such with the public notice.
Yeah, all the setbacks were on the survey. I drew everything on there.
But
No,
there's
but
only
The problem
6
is, it's
feet.
not on our,
No, it's here.
There's only
12.
6 here.
Yeah, but that's not where he's building. He's building this. That's what he's proposing, which is a 12-foot setback.
Right. But we're not giving a variance for construction of the deck. We're giving the fact that you have 2 houses on this property.
Oh, is that what it is?
It's on the fact
Well,
that
because
it's
this-
pre-existing non-conforming 2 on 1.
Right, but he's expanding the use. That's what's going on.
No, only the site plans have to clear up all their other stuff. The houses don't.
Okay.
The existing houses, you don't do the setback.
all right, so it's because it's two houses on one.
We're expanding the
It's a
non-conforming
non-conforming
use.
use.
Right.
That's
But
what we're
now,
doing.
If you have only 12 feet to the lot line,
He only needs 10 because of the size of his lot.
Yeah, it was 10 foot on there, on that one side.
That's why, he meets the setback with what he's adding.
he does.
Yes.
Okay.
Okay, so,
I moved it over a little bit.
and it's
You
in
didn't
the
put
back
flush
of
in
the
the
house to the left, right?
Yes.
To the right, left,
Depends on what street you're on.
yeah. Okay. There's no additional property you could buy to bring this into conformance. Obviously, everything's brought up around you.
Yes.
All right, the board, Silvio,
No questions.
Rose,
No questions?
Bill.
No questions, thank you.
No questions. No questions.
Mark.
No questions?
Okay.
All right, do I have any input from the public on this application? I'll look for a motion to close this application.
Motion to close.
Do I have a second?
Second.
All in favor?
Aye.
Thank you. All right, and number 7, Vincent Scarfone, they're looking for an adjournment for next month. Look for a motion.
So moved.
Second? All in favor?
Aye.
All right, do we need a break? Straight through?
Yeah.
All right, at this point, there's no public input on any applications. Thank you. All right, number 1, Gino Barbaro, I'll look for a motion.
Motion to grant use variance.
Do I have a second?
Second the motion.
Discussion?
It meets all the criteria.
All in favor?
Aye.
Aye.
And I'm recusing.
So noted. Okay. Number 2, Loopy Plaza condo.
Motion to grant with the condition that a highway permit must be issued before, a highway permit must be issued.
Okay,
Seconded.
Second.
discussion? All in favor?
Aye.
And I recuse.
Okay, so noted. Okay. Carla Fire Department's held over. Number 4, we held that over?
No.
No.
Sorry, yeah, New York SMSA Limited Partnership doing business as Verizon Wireless. Look for a motion.
Motion to approve.
Wait, we need to condition that, right?
And any conditions?
The parking meet the bulk requirements that's to be imposed by the planning board.
Right.
You agree to
With
that?
that condition, yes.
Do I have a second?
Seconded. Second.
Any discussion? All in favor?
Aye.
Okay. Number 5,
That was held over.
that one was held over. All right, number 6, Charles Bayer, look for a motion.
Motion to grant.
Do I have a second?
Second?
Second.
All in favor?
Aye.
Okay, and number 7 was held over. Okay, we don't have any minutes, we just got them today, so we really can't, and they're not advertised anyway, so we'll have to wait till next month to carry those. And again, just remind everybody, join us Sunday at 11 o'clock to commemorate Mark Frazier at the Chamber Town Park. And thank you all, have a good night.
Good night. Should I say what's going next? No.